Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in PDR Network versus Carlton and Harris Chiropractic. Certiorari to the United States Court of Appeals for the Fourth Circuit. Argued March 25th, 2019. Decided June 20th, 2019. Petitioners, collectively PDR, produced the Physician's Desk Reference, which compiles information about the uses and side effects of various prescription drugs. PDR sent healthcare providers faxes stating that they could reserve a free copy of the new ebook version of the reference on PDR's website. Respondent Carlton and Harris Chiropractic, a fax recipient, brought a putative class action in federal district court claiming that PDR's fax was an unsolicited advertisement, prohibited by the Telephone Consumer Protection Act of 1991. That's 47 U.S.C. Section 227B1C. The district court dismissed the case, concluding that PDR's fax was not an unsolicited advertisement under the Telephone Act. The Fourth Circuit vacated the district court's judgment based on the Administrative Orders Review Act, the Hobbs Act, which provides that courts of appeals have exclusive jurisdiction to enjoin, set aside, suspend, in whole or in part, or to determine the validity of certain final orders of the Federal Communications Commission. That's 28 U.S.C. Section 2342(1). The Court of Appeals held that the district court was required to adopt the interpretation of unsolicited advertisement set forth in a 2006 FCC order. Because the Court of Appeals found that the 2006 order interpreted the term unsolicited advertisement to include any offer of a free good or service, the Court of Appeals concluded that the facts, as alleged, demonstrated that PDR's fax was an unsolicited advertisement. The Supreme Court held, decision is vacated and remanded, and Justice Breyer delivered the opinion of the court. The extent to which the 2006 FCC order binds the lower courts may depend on the resolution of two preliminary sets of questions that were not aired before the Court of Appeals. First, is the order the equivalent of a legislative rule, which is issued by an agency pursuant to statutory authority and has the force and effect of law? That's Chrysler Corp. Versus Brown. Or is it the equivalent of an interpretive rule, which simply advises the public of the agency's construction of the statutes and rules which it administers, and lacks the force and effect of law? Perez versus Mortgage Brokers Association. If the order is the equivalent of an interpretive rule, it may not be binding on a district court, and a district court therefore may not be required to adhere to it. Second, did PDR have a prior and adequate opportunity to seek judicial review of the order? 5 U.S.C. Section 703. If the Hobbs Act's exclusive review provision, which requires certain challenges to FCC orders to be brought in a court of appeals within 60 days after the entry of the order in question, 28 U.S.C. Section 2344, did not afford PDR a prior and adequate opportunity for judicial review, it may be that the Administrative Procedure Act permits PDR to challenge the order's validity in this enforcement proceeding. The judgment of the Court of Appeals is vacated, and the case is remanded for that court to consider these preliminary issues, as well as any other related issues that may arise in the course of resolving this case. The decision below is vacated and remanded. Justice Breyer delivered the opinion of the court, in which Chief Justice Roberts and Justices Ginsburg, Sotomayor, and Kagan joined. Justice Thomas filed an opinion concurring in the judgment, in which Justice Gorsuch joined. Justice Kavanaugh filed an opinion concurring in the judgment, in which Justices Thomas, Alito, and Gorsuch joined. Thank you for listening. If you'd like to get a hold of the podcast, we can be reached at rhodesscholar80@gmail.com. That's ROADS and 80, or on Twitter @CourtSyllabus.